Well, hello. Hope everybody had a wonderful, wonderful Saturday. Thank you so much, Ricardo. Hi, Miss Cassidy. I missed you. Hi, lovelies. I miss you guys too. I really do. Like when I can't come around for a couple days, I'm like, I haven't been live for a few days. I really, really missed you guys. But we are back to Charles Babcock, and boy, did we miss this man. Yes, Chip, our darling, darling Chip. I one of these days, if I ever hear this man's in actual court, I will be flying to Texas to hear this man speak. He is absolutely amazing, and so it was absolutely a delight to get to read his words again. I will still be covering the Jed Wallace case and also the Jones versus Abel case, and then transitioning back to the Murdaugh stuff as that's heating up. So his murder conviction was reversed by the South Carolina Supreme Court. Very, very disappointing indeed. But we have been assured by the Attorney General's office that he will be retried and that it will happen in this calendar year. So if you aren't familiar with that case, I'm going to be doing some catch ups, some just kind of like starting from square one, introducing what all happened in that. So if you guys want to join me in talking about Murdaugh, I will be thrilled to see you all there as well if you're interested in that. But anyway, so let's get to this because as usual, I have trouble keeping my my sense of timing going. I have time blindness. I have no concept of time, and I always have way too much to say and way too many slides. So I want to just jump right into this. So this is the Blake's attorney who's been covering the case in Texas, I believe, since the very beginning of this. And we're going to kind of walk through the history of all of this. It's Laura Lee Prather. She is a Texas attorney. And Laura, oh Laura, I've got big questions for you, Miss Ma'am. Because looking at your bio here, how do you boldly proclaim this stuff and represent the woman who subpoenaed 107 content creators? A way that really was an attack on First Amendment, our freedom of speech, our ability to speak freely and report on things and express our opinion on things was really in danger by your client. And this is the trend right now, and it's a scary trend, and it's a trend that needs to be stopped. It is exactly what happened in that hearing yesterday, where a content creator, well, she's a bona fide journalist, a podcaster, and she was being subpoenaed in what really does appear to be just what it was in our case, an attempt to shut us up and take away our right to express our opinions on YouTube or whatever platform we use to express that opinion and to talk with you guys and let you express your opinions. Carrie, I love it when you babble, Cassidy. It's the babble that makes you you. And I am full of babbles. But this is a very alarming trend, and it has to stop. But it's just so crazy to me to see this woman who on her bio self-describes as being this zealous advocate for free speech rights at state house and courthouse. She specializes in First Amendment, anti-SLAPP, and intellectual property disputes. She represents, get this, content providers, including online and traditional publications. Really, Laura? Are you not aware of what your client did to us? cable and terrestrial broadcasters, streaming media platforms, podcasts, production companies, and music and sports entities. She's described as very well versed on First Amendment law. Her clients value her dedication and work ethics. How do your other clients, your content provider clients, how do they feel about you representing Blake, who came after us like that in a very, very dangerous effort to get our private information, our credit card information, our bank information, our subscriber information? Like, how do you balance this? And how, if I, as a content creator, I would never come to a person like you who represented Blake Lively and what she did to us. So this is just crazy to read this on your bio. Let's just start with that, Laura. I'm looking at my notes because I, went off script and started to babble. How do you join forces with the law firms that carried out Van Zandt and access Jen Abel's entire life from her phone? How do you balance that out to yourself in your mind that it's okay to join forces with those law firms and represent that client that did this? If you had an ounce of integrity, you'd have walked away from this case. But here you are, spewing the nonsense you spewed in this document we're going to talk about today, pretending to be an advocate for women. And so you get something that others like you have gotten before. You get a big old shame on you, Laura. Shame on you for this hypocritical behavior. All right. And that's my TED Talk on Laura. Okay, let's go on with this document. Like I've said so many times with the Blake Lively crew, that when their documents first get filed, I can barely get through. I could barely get through the table of contents, honestly, reading this. I'm like, really? Just look, I've highlighted a few of the points. Miss Lively is entitled to an award of reasonable attorney's fees. We'll see how reasonable that is. Under California Civil Code 47.1, they're coming after Jed Wallace with 47.1. And they say successfully defending herself in this action. How successful was it really? We'll talk about that. And then under that heading, we see Section 47.1b applies to Miss Lively's claim. Miss Lively's allegedly defamatory statements are privileged under Section 47.1. Miss Lively's allegedly defamatory statements are communications protected by 47.1. Her allegedly defamatory statements were made without malice. Miss Lively had a reasonable, sorry, let me move the comments for a second, basis to file her complaint. So you see what I'm saying? Like, I couldn't even get through that. So what I did is what I always do. I wait until the other side responds, and then I can stomach that, because it's like a spoonful of sugar helps the medicine go down. This is the spoonful of sugar that gave me the energy to be able to read this nonsense we're about to go through. And it's nonsense. As you see, when I say that I gag reading it, I mean it. It is gag inducing. Here's what she says. Defendant Blake Lively respectfully submits this motion for attorney's fees. She quotes 47.1, sorry, FRCP 54D. And then we get into the local rules. These are the Texas rules now, CV 54 and California Civil Code 47.1. I thought I would never, ever, ever hear about this again, but it looks like it's going to stick with us. I'm sure it will not be the last time we hear of this. This is what the big old fight is over in all of this. Blake trying to recoup some of the money that she has wasted on these attorneys who I've been saying for months to Blake, these people hate you. They want your money, and they're not doing you any favors with this lawsuit. But now she has to try to recoup some of that, since her settlement agreement did not involve a single dollar. Not a single penny So she's got to recoup them in some way, and this is how she's attempting to do it. And they say, not surprisingly, that they've conferred with plaintiff's counsel. Jed is the plaintiff in this case. So it's a little confusing to get used to seeing plaintiff not meaning Blake, but in this case, plaintiff is Jed Wallace and Blake is defendant. We're unable to resolve the dispute by agreement because plaintiffs are opposed to the relief requested in this motion. Of course they are. Absolutely, of course they are. And so in the introduction, we get the background that they claim that this is exactly the kind of retaliatory defamation litigation California sought to deter when it enacted California Civil Code Section 47.1. Miss Ma'am, this is a California state rule. I am absolutely certain that they did not intend for this to be applied in Texas to a man that did not sexually harass anyone. And to defend himself from a case that came out in the New York Times, I mean, they're by a millionaire. I take issue with them saying that this is exactly the kind of case that this law was written for. I mean, I made an episode where I went through and found the videos of where this law, back when it was, I think it's 933 was the bill, and I went through its whole birth. And I don't mean to sexually harass this bill when I say its birth, how it went through the different sessions that they talked about it, described the purpose of it. They answered questions about it up until ultimately it was passed into the statute. So, but I take offense when they say that this is the kind of case. This is a millionaire with fraudulent claims. It's just nonsense. This is not the case that this was written for. Plaintiffs brought this action to punish Miss Lively. No, Miss Lively brought her action to punish them for reporting sexual harassment that she never reported. She never produced an official reporting. And I know that this says that it doesn't have to be official. It can be by other means, but even still, it was something that she claims happened like a year and a half before she finally actually filed some kind of complaint. That there's just no way to link that in time or say that it has anything to do with the stuff she claims was an actual report. And for communicating the factual basis of those reports through formal channels, including her protected complaint with the California Civil Rights Department, having forced Miss Lively to defend against a meritless defamation suit in a distant and inappropriate forum, plaintiffs should now be held to the statute's deterrent consequence: payment of Miss Lively's reasonable attorney's fees incurred in successfully defending herself in this litigation. So in Blake's fairy tale, this PR guy who got blasted in the New York Times would have no other reason to sue her for defamation than to retaliate against Blake on behalf of someone he never met. How does that make sense? Not that he has a business and reputation to protect that she put on blast in the New York Times. No, it's not that. It's because Blake claims she reported SH that she didn't file until a year and a half later, when she illegally obtained all these people's messages, including Jed's. Yeah, that makes sense. It has nothing to do with that. It's all about this little non-formal complaint that was taken care of. It's insanity. And her complaint was not filed till December. So how can she claim that any of it is retaliatory? How did you go back 6 months and say, oh, okay, or no, more than that, because it was supposedly back in May, retro stamped somehow. It's just insanity. And just that anyone would believe that this man is filed a suit to retaliate about Wayfair and not about her, what she said about him. It's It just boggles the mind. No one's going to believe that. The man is simply defending himself and defending his business. Okay, moving on. So leaving out the part about filing these claims with malice, because she drones on and on about that and about this statute. So I skipped all of that to try to shorten all of this. Now we get into the rest of what she says. So she's, oh, I forgot to advance the slide. Sorry, guys. So the alleged defamatory statements that formed the basis of the plaintiff's lawsuit meet all of the elements of the privilege statements under that section, section 47.1, really. Its remedies do not depend on a merits adjudication of the defamation claims, because that's something that Jed says. The statute requires only that the defendant successfully defend against the action. But did she? Miss Lively did just that. Well, we'll see what they say about that. Let me see. Look at my notes again real quick. So here's the issue of many issues. If it has this malice qualifier, merits matter. How is it proven that she filed this without malice? And 47.1, this is one of the things that I've said since, well, last year, is that this malice qualifier, because Blake, and because I went through the history of how this bill became a law, and it does have not one but two qualifiers. It has to be factual, and it has to be done without malice. It is impossible. And what Blake is trying to say, and even the people who wrote the amicus briefs, what they all tried to say is that this 47.1 is a magic wand that you can wave, and as soon as you pull those numbers out and put them on a document, that you don't have to give discovery, that you don't have to prove anything, that it's just bam, the case is dead in the water and you win and you get triple. Sorry guys, hold on just one quick second. Sorry, had to drink a little something. I got little lightheaded. I just realized it's like 9:13 p.m. here and I haven't eaten a single bite of anything today. I've got to stop operating like this. But anyway, how can you say that the case goes away like that if you have to prove that you did not make these claims with malice and that they are factual? Those qualifiers require some sort of merit. They require some sort of proof. So saying that it's like this magic wand that does away with everything is not accurate and is not true to what this 47.1 actually states. They have misinterpreted it, in my opinion, to try to apply it in that way. So and Blake cannot say that she successfully defended, and we're going to talk about the ways specifically with this Texas case in a moment. But even if you refer to the New York case, her team is off declaring that they won, that it was some kind of huge victory for Blake. But that's not true, even with the Wayfarer people, but especially not with Jed, because Jed was dismissed not once, but he was dismissed twice. The individuals that she tried to sue that remained in the action, it was only 3 companies left, and she settled with them. And she settled with them for $0. That is not a win. So between the two lawsuits, there's not any way that she can say she successfully defended anything. There are other issues with Jed Wallace's case because he was just his motion to her motion to dismiss against him was granted, but it was granted without prejudice. That means he can come back and correct. And it was granted based exclusively on jurisdiction. That means he can refile this in another jurisdiction. It's not dead. It's not over. And as long as it's not over, she cannot claim any kind of success in defending this action because it's not done. It's still open. He can still come after her in another jurisdiction. And right now, he has this case itself is he filed a motion to appeal this. So there's nothing ended about it that she can say that she has successfully defended that. And like I said, we'll get into more of those details in a moment. But it's just kind of crazy, like talking about success. What in the world kind of logic is that? But her attorneys, and now it includes Laura, they will write just about anything. That she tells them to write. They know, they have to know. We know this is not correct. And yet they write it anyway on these court filings. I would be embarrassed to file something like this knowing that it's not true. But I guess you got to do what you got to do for your client. This is why I couldn't look at myself in the mirror and do this kind of stuff. So, what do I have here? Yeah, she mentions it again here, and once she gets into the argument, that she's entitled for successfully defending herself in this action, and then she goes into the California law. And now what they talk about here, because this case is in Texas, they do talk about Texas choice of law principles. And we saw this kind of argument be made not so long ago in the Blake case, because like the New York Times, for example, they fought and won to get New York choice of law applied to them. Because, and if you don't remember, or if you weren't around then, federal court has procedural, and we're going to talk about this a lot today. They cover procedural rules, but for the actual substantive rules, that comes from state laws. And so when you're in federal court, and usually you're in it for this is one of the big reasons that you're in a federal court, is that you have people from multiple states. And so, like in the New York case, we had people from California, we had Jed from Texas, we had people from New York. Sorry, hold on just a second. My inner monster came out. So they may each want their own specific state law applied. They're more familiar with it. It might be kinder to them. And so you have this choice of law discussion to determine which state laws are going to cover those substantive laws that they're going to go by when deciding this. And so that's what this most significant relationship test, each state has a test. They're usually very, very similar. New York's is a little bit different, especially when dealing with the press. But this is one that you see a lot in a lot of the states, this most significant relationship. So that's what they do when you have people fighting. If everybody agrees, yes, we're going to do Texas law, then there's no issue. But if one party wants a certain state and the other party wants another state, then you have to go through these tests to determine which state is the best application. So that's what's going on here. And so according to the Texas choice of law principles, it has these four standards for their test. Where did the injury occur? You see this in almost every state. Where the tortious conduct occurred, where the parties reside, are domiciled, are incorporated, and conduct business, and where the relationship between the parties is centered. These are all pretty standard. There may be some of these missing or some additional ones, but this is kind of pretty standard across the board about how the states go about determining this. So they claim that these principles weigh heavily in favor of applying California law. And we've seen this with Blake. And it's of course every firm who has a client in the battle, they're naturally going to fight for the laws that help their client more than any. But what's really, really funny about this to me is that we saw Blake, she filed her complaint, her first complaint. Then she had one amended complaint, and then she had a second amended complaint. And that second amended complaint, if you remember, it came about specifically for Jed Wallace, because it was when Jed Wallace had been dismissed from the case and Blake wanted him back in. And so she fought and fought. And do you remember what her fight was? You remember, if you've been around here for a bit, my favorite piece of evidence is Blue Jean Baby, New York Lady. Do you remember? That was like her huge piece of evidence that said that Jed Wallace should have known that she was a New York resident. And then there was the time zone, because it was Eastern time zone, so he should have known that phone call happened in New York, even though it goes all the way across to like Michigan. And so it could have been any of those states. There are so many states in the Eastern time zone. But anyway, that was her last pleading in this case, was that pleading, her second amended complaint. And it was all about New York, New York, New York, because it was all about trying to bring Jed back to the case. So she had Blue Jean Baby, New York Lady. She had that because Jen Abel was in New York for the Wayfarer premiere or promotion or whatever was happening in New York, when she reached out to Jed to hire him, and there was contract talk and those phone calls, those Eastern time zone phone calls, and all of that was to prove Jed Wallace's New York connection. And now we have her in Texas, with that being the final pleading, the only pleading that matters, because once you amend your complaint, the other one becomes moot. So her original complaint and her first amended complaint, moot. The one that was still standing in court was the New York. This is all about New York. And now she's trying to say, oh, it's California, California, because she wants 47.1. And she's not fooling anybody to say otherwise. And so this is natural. I mean, it's why she filed her CRD complaint in the first place. And it got admitted by her attorneys in a hearing. It is in the transcript. It is on the record. There is nothing they can do to live that down or get rid of the fact that that's what her attorney said, that it was for these extra damages. So here we are. We know exactly why she's saying that it weighs heavily in favor of applying California law. No one is fooled here. All right, I'm taking too long. Let me try to shorten these down. I got so many more slides to go. Sorry, guys. So they say, first, the conduct causing plaintiff's purported injuries took place in California. The basis of plaintiff's defamation claim was Miss Lively's filing of the CRD complaint in California. And yet that argument did not help Wayfarer when it came to the New York Times. The New York Times wasn't able to they were able to make it happen. Oh, no, wait, I got this confused. I'm saying it wrong. I'm sorry, guys. Forgot what I was trying to say. I looked at, I saw all caps in the chat, and then I got alarmed, and it caught my eye for a second. Let me come back to this. The basis of plaintiff's defamation claim was Miss Lively's filing of the CRD complaint in California. However, what happened to all of that? What happened to her Title VII and all of and her? Well, that was to do with her not being an employee, but like the FIHA, she lost the sexual harassment complaint because she filed it in California. And that's not where the allegations were supposed to have taken place. She lost all of this. So how is she throwing it in this when a court has already said you filed this in the wrong state and therefore you lose your complaint, your causes of action? But here we are, acting like none of that happened and still fighting for California for all of this. Second, Street was incorporated in California, and Wallace conducted his business through Street, a California corporation, which has since moved to Texas. Miss Lively is and was domiciled in New York, not Texas, but it's not Miss Lively's complaint. It is Jed Wallace's complaint, and he lives in Texas. And we well know that one of the reasons he did not want to have to deal with coming to New York was because he was experiencing some serious health issues that Blake went and doxed out there, didn't seal correctly while she was sealing something about a Thursday. She did not seal his private health information. But anyway, none of that matters because Blake's domiciled in New York. And the relationship was centered in California. But was it? Okay. Let me check my notes to make sure I didn't miss anything on this. Okay. All right. I think I covered all of that. Okay, so it moves on by saying the only connection to Texas is that the plaintiff, and here only one of the plaintiffs, Jed Wallace, was residing in Texas at the time the alleged defamatory statement was made. So even though Street, so they're saying because Street was a California business, but then by their own admission, Jed himself resided in Texas. And we've also seen that Jed says that he did not have a team, that he was working for himself. So if Jed was in Texas at the time, it doesn't matter where street address was. It was coming out of Texas. Without any specific allegations that connect to Texas specifically, aside from one of the plaintiffs' mere residence in Texas, which holds is insufficient. So it's kind of crazy to me. I mean, his business may have been registered in California, but the actions, if Jed was the one, by his word, he says it was me, I didn't have a team, it was me doing it. If he was the one doing it, how did the actions occur in California? What was he doing? How was he doing that? Did he, every time he wanted to look up something, which according to him, he was simply monitoring? Every time he wanted to monitor, he had to fly to California and look it up and then fly back to Texas. Is that what he was doing? I mean, it's absolutely insane to admit that the man who was running things resided in Texas, and then to turn around and say that there's no connection to Texas. It doesn't make sense. Okay, let me look at my notes again. Okay. And it's just funny too that that she did all this in New York just based on where she resided, and then tried to apply for allegations that supposedly happened in New Jersey, and then tried to bring California law into it. So it's just so funny to see them condemn somebody else for actions that they did themselves and even went way beyond. And now we finally get to this this is one of the qualifications under section 47.1, and it's the second thing, that it's made without malice. We also see that what I said earlier, that it has to be factual information related to an incident of sexual assault, harassment, or discrimination experienced by the individual making the communication. So she lost those claims. And toward the end of her lawsuit, the last several months, we saw her really pulling back on even saying sexual harassment. She was more or less talking about a hostile workplace. Do you guys remember that? As more and more evidence came out through discovery, we started to realize this was not sexual harassment. People were not backing up her claims. And so they started to really pivot more towards hostile work environment. So it kind of calls all of this kind of into question, because it seems like her claims of sexual harassment were failing, and in the end they were dismissed. So one by one, videos that got released proved that it didn't happen. Like I said, she was losing support. None of the witnesses seemed to want to be able to step forward. We saw the list of potential witnesses. None of them were people that actually were on set when these allegations occurred. They simply weren't part of the witness list. And then there were people like Jenny Slate, whose deposition was not supportive. Angie's deposition was not supportive. Alex Sack's deposition was not supportive. So her claims were truly failing, which is why she ended up having to lose them. She had to settle. She lost 10 of them, and then she had to settle what was left. And let me move the comments for just a second. In fact, each and every statement that plaintiffs identified as defamatory relates to incidents of sexual harassment or retaliation experienced by Miss Lively. They say these things, yet that is not the case when you start going through each of these things. Let me move on, try to speed up just a little bit. And now we get to why I will die on the hill that 47.1 is unconstitutional. Because this is what they try to say, that the privilege under section 47.1 attaches regardless of whether a complaint is ever filed and no matter to whom the communication is published. The protections would apply to individuals who, after relaying any factual statement, whether in the form of a formal complaint or a statement outside a formal proceeding, such as to a media outlet, are sued for defamation. And it just sounds crazy to me. Imagine being a man and you get accused of this, and all of your power to defend yourself, you just got to sit there and take it. No matter who she runs to, if it's the New York Times who tells the entire world that you did this, you cannot come back and say, hey, lady, you're defaming me here. That is unconstitutional for so many reasons. You have a right to defend yourself in court, and any kind of statute that comes out and takes that away from you is just way off base. It is self-evident that Miss Lively had a more than reasonable basis to report her workplace. Self-evident to who? Because not to all of us who were reading it, not to what you claimed was voluminous evidence that was going to prove her accusations or her allegations. It never materialized. What reasonable basis did she have? Miss Lively's complaints were grounded in detailed factual allegations. No, they weren't. Contemporaneous documentary evidence. What? Her sitting there saying all this crap to Jenny Slate and Taylor Swift? Is that the contemporary documentary evidence that you're talking about? Her texts to Ange, and then we see what Ange actually thought of it all? Is that the evidence you're talking about here? And third-party communications reflecting a coordinated retaliation campaign following her reports of sexual harassment. No, no. Over a year had passed, and you and Leslie Sloan were slipping out stuff about these people, and they were protecting themselves, and they were talking about it. And in these third-party communications that you're talking about, they plainly say in there, "This is not us. This is not us." How many times do we see them make statements like that? Nothing in those communications talk about any sort of retaliation or any sort of sexual harassment claims. They are completely disconnected to any of that in time, in space, in reality. Nothing in the amended complaint plausibly suggests that Miss Lively fabricated her allegations, acted out of animus, or lacked a reasonable basis to come forward. Really? Okay, and then they come back to this sorry, I keep saying that. Successfully defending themselves in litigation. And so they're talking about their reasonable attorney costs. We'll get to that. Plus treble damages for any harm caused to them by the defamation action against them. We already talked about that. We'll talk about it a little bit more. Miss Lively was the prevailing defendant in plaintiff's defamation action under section 47.1b because she successfully defended herself in the litigation. No, she didn't, though. We already talked about that. I don't want to repeat that too much. And then we get to how they try to back that up. So they say this 54D2B, and they say that Miss Lively estimates, now we get to the reasonable attorney's fees, estimates the amount of attorney's fees sought in connection with the dismissal motion and related filings at approximately $800,000. And that doesn't include these fees that she's preparing now in litigating this motion. So we're talking close to $1 million in reasonable attorney's fees for this nonsense, for this absolute nonsense. And now we get to the footnotes. And here's where she starts to say, well, you know what? Normally, you have to, the courts require an affidavit as to the value of services be submitted with the fee application. But we don't have to do that, Judge. You can just say that I deserve these, and we can get to all those little details later. It's just crazy the way she's taken authorship now of Texas law, and oh, I shouldn't have to submit these attorney's fees so that you can look at exactly what this ridiculous number comes from, how it gets broken down. No, we don't need any details about that. We just need you to tell me that I get these fees, and we'll deal with what these fees are later. It's just the gall of these people. Like, what kind of lives have they lived that they feel so precious as to be able to ask again for the courts not to follow the normal rules that they usually follow, and she gets some kind of special treatment? It's just this celebrity privilege all over again that we're still dealing with. Okay. Now we'll wash all that filth off. Oh, thank you, Jane. It was so cool to be there. I can't wait to talk about that episode. I'm trying to arrange someone to join me on that episode. So, but it's coming soon. Hopefully tomorrow. We'll see. But yeah, let's shower off the filth of that document and let's get to Mr. Babcock's masterpiece. And he comes with the power of binding case law and not just empty claims. He brings binding case law from his circuit. He's in the Fifth Circuit. We finally get out of that dreaded Second Circuit. And also, he brings a new decision from the US Supreme Court, which excites me to no end. You know how I love that law nerd stuff. And so I was super duper excited to see this. This was decided just a few months ago in January of this year. So it is a shiny, brand new Supreme Court decision. And I'm so excited about it. But I'm excited about it for very personal reasons as well. I will link it in to this video once this video posts. I did a video months and months ago, last year, where I went through the Erie Doctrine and all of this. Like I said, we're going to talk about procedural versus substantive, and it sounds really confusing, and it is really confusing, but I went through the history of how federal law versus state law developed and how these things are determined and what this Erie Doctrine is, and then how other cases came along to add a little bit more to it to let federal courts know how they need to decide. Because here's what happened. There was the federal court and then there was the state court, and there could be a very different outcome based on which court. It could be in the same state, but one was in the federal court and one was in the state court. It could be a very different outcome based on whether it was in the federal court or the state court. And so it had to stop because what we had happen was forum shopping. Naturally, they would choose the court that helped their client and then themselves because they got bigger fees, and it got really, really messy. So all of this came about, and I explained all that in detail with pictures and little cartoons and stuff, how these cases came about to equalize across the country to make the outcome much more similar, if not the same. And so did away with forum shopping. But in there, I explained what is procedural, what is substantive, and what is ruled by federal courts, what is ruled by state courts, and who has the upper hand if there's a conflict. That is the very important thing that is decided in this new US Supreme Court case. But what I'm really excited about is that in that video that like I said, I'll link it later if you didn't see it, is that oh, I looked at Jane's comment and my brain went straight to Murdoch again. Sorry, guys. Hold on. Let me get myself together. In that video, I talked about what I thought was going to happen to 47.1 based on how anti-SLAPP is dealt with in federal courts. Most federal courts do not entertain anti-SLAPP. The U.S. Supreme Court has never ever taken a case that deals with anti-SLAPP, and they've had plenty of requests to rule on them. But here's the problem. Not every state has anti-SLAPP. Some states have had them, then done away with them, then rewritten them and brought them back, but only 35 states at my last count actually use that. So here's what you have a problem. When you have federal court trying to decide an anti-SLAPP, but it's in a state that doesn't recognize anti-SLAPP, you have a huge issue. There's a huge conflict that's not easily settled. So if the US Supreme Court were to rule on it, and their rules are binding, then what does that do to the states who don't have anti-SLAPP? So this was the issue that I had said that I thought would be a problem with 47.1. Now here's the thing, and the argument that Blake Lively will no doubt make is to say that 47.1 was specifically written to not be considered, they do not consider themselves anti-SLAPP. They have these little workarounds to claim that they are not. However, as Jed, uh, as Babcock argues very well in here, that it doesn't matter so much what you call yourself as how do you actually perform in court. So you can say, I'm not an anti-SLAPP, but how do you conduct yourself in court? How do you perform in court? If you perform like anti-SLAPP, then you are. If it looks like a duck, walks like a duck, quacks like a duck theory. So that was what I thought was going to happen to 47.1 when it gets decided, that it was going to go the way of anti-SLAPP. And Wayfair had mentioned that actually. And ultimately, the judge mentioned that because they said, the federal courts do not entertain these. And Judge Lyman said, well, that's not exactly true. Sometimes they do because the Second Circuit has. But as a whole, they do not. But the Fifth Circuit, so they have their ruling, they absolutely do not. So this is what they're facing in Texas. And so this is one of Jed's big arguments. And then we're going to get into these. I'm getting a little bit ahead of myself, but I got so excited about this because I had not met Omar yet. I knew who he was, but I had not met him yet. And he had come across my video where I talked about all of this. And he took my video and he did a video saying why he disagreed with my arguments. But what I absolutely love, and I'm going to love to like in your face, Omar, as soon as I can, is that these cases say exactly the argument that I had said, that he said I was wrong in. And one of them being a shiny brand new US Supreme Court case, delights me almost as much as Kevin Fritz saying my name today. But anyway, so yeah, I've had lots of delights in the last couple of days between Kevin Fritz and Tabor Vox, and now the US Supreme Court backing me up. I'm so excited to bring this to you today. So let's get into this one. So he says, and oh my gosh, I love his words. Unbelievably, Lively is once again back for relief from a Texas court. I love it because he makes her sound every ounce of ridiculousness that she is. This time, she twists the court's determination that it lacked personal jurisdiction over the claims against her as a decision on the merits of one of her affirmative defenses. This, she says, entitles her to a staggering $800,000 in fees. And then he puts in parentheses, or more, because she is asking for more, plus court costs. I love this line. Under a wishful reading of a strictly procedural California statute that does not apply in federal court, but even if it did, would not give her the substantive relief that she wants. And his footnote says, Lively is not entitled to any fees, but plaintiffs reserve the right to challenge on some future date whether this stunning amount was reasonable and necessary otherwise. I love when attorneys bring this kind of spice, this kind of personality, not just some dead drivel, some boring nonsense. Like, put your heart in it. Really and truly put your heart in it. Fight for your client and make Blake Lively and her entire team look as every bit, like I said, of ridiculous that they are. This is delightful to me. I just absolutely love the way he writes. Okay, let me check my notes again. Okay. Okay, Lively's request to make California procedural law apply here, and this this footnote refers to something that we'll get to in just a little bit. It's section 3 of this document. Is part of an ambitious plan to have plaintiffs pay her for a lawsuit prompted by her publication to the national media that plaintiffs, among other things, sexually harassed and retaliated against her, though they've never met her or been in the same room with her, and breached a contract with her, though they've never had a contract with her. No reasonable basis, Lively had no reasonable basis to make these allegations about plaintiffs to the California Civil Rights Division, the media, or anywhere else. And even if she did, the Fifth Circuit rejects such procedural relief in federal court. And this is that circuit case, the binding authority there in Texas that I talked about. Okay, let's see. So we're going to talk about this CRD in a moment, as well as deep dive this procedural relief and federal court. And that procedural is what I was talking about in a moment. Yes, I just saw your comment, Pam. His cheekiness. It is. That's the perfect word for it. Cheekiness. Okay. And then we see my shiny brand new US Supreme Court thing. We'll get to that as well. But these two cases, oh yeah, I wrote something really cheesy that now I feel kind of cheesy to say. But when I was writing it, I was like, like some people get excited about new car smell. They get in a brand new car and they take it for a little spin to see how it drives, and they just breathe that new car smell. And that was like how I felt when I saw this like new case law smell from the US Supreme Court. And then I wrote, yes, I'm a nerd. But and this, we've seen this happen so much. What he says here, to get her desired result. We see this. Thank you. She loves you. She loves to learn. You're safe with us, Cassidy say. You guys are used to my cheesiness by now. Sorry. My monster voice keeps coming out today. These allergies, has been such a bad year. This is what they've done. This is what they've done throughout the case. Instead of looking up case law, I've said this about the judge too. I've felt in some of his orders he wanted a certain outcome, and then he found case law to support that. In two cases that I can think of, they were unpublished cases. When there was published case law, it just didn't match what I felt he wanted the result to be. And so that's what a person does when that's what this means, working backwards. So her attorneys throughout this whole thing, that's what they would do. They wanted the law to be a certain way, so they would go through and find case law, and they couldn't find it. And so they would use dicta and try to pretend that was binding somehow, and it wasn't. It was kind of ridiculous, but that's what they're doing again here in Texas, performing a surface level conflict of law analysis that ignores where the injuries to plaintiffs occurred. And that's like, these are my injuries, and they occurred in my hometown, my home state, and the interests of her home state, New York, before concluding that California law applies. Lively's reason is as obvious as it is self-serving. Neither Texas nor New York have the same procedural statutory scheme that would allow her to recover the hundreds of thousands of dollars she seeks for filing a motion to dismiss. But even if California law applies. Hold on. Sorry, guys. Lively is not a prevailing defendant. The court has not determined, as Lively says, that plaintiff's claims were meritless. So he's basically saying, hold on. You're getting ahead of yourself here by making this bold claim. And Beck, again, this, unfortunately for Blake, her attorneys have admitted this. Like I said, there are transcripts from this hearing where they said, when asked by the judge, why did you file this in California? And they said for the extra damages. It was a crazy admission to make. We all knew it. We did. But now we have absolute confirmation straight from the horse's mouth. And so that is going to be very, very harmful for her going forward, trying to do what she's trying to do right here. We have some beautiful more binding authority. He's really bringing it. I love to see that. You guys, if you followed for a while, you absolutely know that I love to see that binding authority here. Instead, the court told us that it did not reach the merits of any defense. And that's what the court said. Nor could it. Why? At the pleading stage, a court is limited to making findings of fact related to jurisdictional matters on a motion to dismiss. Now, we went through all of this very, very recently in the Wayfarers portion of the case. We had the two different types of dispositive motions. We had the MJOP, we had the MSJ, and earlier we had the motion to dismiss. And I think we all learned a lot from Little Girl Attorney and from Not Actually Golden and from Brit of Commit to the Brit. We learned so much from these people and their good explanations of what these dispositive motions are based on. So like the motion to dismiss and the MJOP, they're based just on the pleadings and no facts, no evidence, none of that. But then the motion for summary judgment involved much more and the evidence collected at discovery, the depositions, all of that good stuff. So we understand the differences in that. So that helps us understand what he's saying here. So at this point, he filed the complaint and Blake filed a motion to dismiss, claiming there was no jurisdiction to link her to Texas. And that was dismissed without prejudice. But in that order that granted the motion to dismiss, it said that they, just like how any judge would say, there's lack of jurisdiction, so we don't consider anything else besides that. And it would be wrong for them to consider anything else beside that. They didn't say who had a better case, none of that. It was just, we don't have jurisdiction for this. And when you don't have jurisdiction for this, you can't make any decisions on merit or otherwise because it doesn't belong in your court. And so this is what they're saying. There was no merits reached. It was just, I don't have the authority to do this. That's what was decided. And so like these cases say, a court must find that it has personal jurisdiction over that defendant before it makes any decision on the merits. Even then, it only resolves facts in favor of the parties that invoked the court's jurisdiction, which is the plaintiffs, which in this case is Jed Wallace and Street Relations, not the one seeking dismissal, which is Blake Lively. So her making the claim that she won this, that she was successful, is absolutely ridiculous. All right, so Team Blake, including all of those amicus briefs, like I said earlier, the way they treat 47.1 is like it's some kind of magic wand that can just wave everything away, and that they ignored the requirements that are built into it. And the main one being that these allegations cannot be brought without malice. So I'm going to read just this first portion. Lively asked the court to conclude that her statements were privileged under 47.1, while apparently asking the court to disregard plaintiff's well-pleaded allegations of malice that defeat that privilege, requiring that a communication can only be privileged if it is made without malice. So this is where you have this contradiction. One of the definitions of malice is making a statement that is knowingly false. So he's saying she made a statement that was knowingly false. And so that proves malice. And that would take that privilege away. So one of the things he says is a problem is that she filed this CRD complaint that has his name on it. And it's tied together with claims of sexual harassment. So when you look at that and the way it's presented and the way the article from the New York Times is presented, he could be rolled all into this. And he says that he pled in great detail that Lively had knowledge that the statements that she made about plaintiff were false. So he's saying there was malice. So she can't make these claims that 47.1 makes her statements protected. Oh wait, sorry, I wasn't supposed to advance that yet. And then they say what I've been saying, she cannot do this at the motion to dismiss stage. This is true under Fifth Circuit law regarding motions to dismiss in federal court. And it is true under California law on motions to dismiss in California reviewing section 47.1. And I love this little smart remark, which Lively says controls the day. Lively puts us in this procedural posture. There's that word again. We're going to get to that. She cannot now avoid the effects of that decision, much less seek to benefit from it through a novel reading of the law. Novel reading means it's new. It's not been decided before. In any event, the case is not over, whether by plaintiff's appeal pending in the Fifth Circuit or by plaintiff's right to replead the same defamation claims against Lively elsewhere. So like I said, because it was dismissed without prejudice, if his appeal on this motion to dismiss is not successful, he can still go to another jurisdiction and sue her. His claims will not be dead either way. They're still alive right now because he has an appeal pending in the Fifth Circuit right now. Okay? That means Lively hardly successfully defended herself, such that she is entitled to a nearly $1 million in fees and court costs. The great irony of Lively's motion is that it forces plaintiffs to spend substantial time and resources responding to point after point made in her motion, despite the motion's substantial flaws from end to end. I love this. In the process, Lively turns the true goal of Section 47.1, a foreign statute with noble aims, on its head. Indeed, this is what I've been saying for so long. She's ruining this law for true victims, for people who truly needed something like this, while refusing to acknowledge the serious consequences of her defamatory conduct. And my first post, I've said this so many times, my first post, when I came to the realization, because I believed Blake at first, when I read the New York Times article, I was disgusted, didn't know who Justin was. When I read her first complaint, I was disgusted, didn't know who any of those people were. I was just absolutely disgusted. And then started to read the responses and saw the dance video. And then I was like, oh my goodness. And my very first post was on Instagram, and I posted it before I started covering it on YouTube because I was still a little bit hesitant. Like, I don't want to go, because all of my stuff before this has been completely in support of women. completely in support of women. This is the first time in my entire life that I have not supported a woman in this kind of thing. The very first time. And so before I started covering it on YouTube, I took a picture of Blake that looked kind of smug, and I said, the face of the woman who is single-handedly ruining the Me Too movement, because I was so angry that such a high-profile case, women are actually assaulted every day. I forget how many seconds. It's something like every 68 seconds. It's some alarming, horrifying statistic that I don't even want to think about. And 1 in 3 women are victims or will be victims at some point in their lives. And when I think about the number of those women, that is childhood assault or abuse, I just literally want to vomit. But these are very real statistics, and these are not somebody said my pants were sexy, or somebody said my sexy scene was sexy or hot, or somebody told me to take a coat off because the temperature in the room was hot. I'm talking about real women and real little girls who have been violated in the worst way. And this woman comes forth, and she, of all people, gets a story in the New York freaking Times. Not just a story, but a humongous story and an accompanying video. And her claims amount to this pile of nonsense that we have spent a year and a half looking at. And I am disgusted, and I'm angry, and I'm furious, and I'm enraged that she did this. And Harvey Weinstein, and the point of my post about her single-handedly ruining the Me Too movement is that every woman who comes forward and abuses the courts and makes these fraudulent accusations makes it to where women go back to the point of being laughed at and scoffed at and not believed. And we lose decades worth of work of brave women who sat in courtrooms around this country and were questioned about having been assaulted and were asked, well, what were you wearing? Were you wearing a mini skirt? And made to feel like it was their fault that some animal didn't control himself. Those women suffered for decades, and the few that were strong enough to go through with those cases did that to protect their daughters and granddaughters, to hope for a time that would be better for women where we would be believed. And these kinds of fraudulent, ridiculous, and it's why I can continue to cover this lawsuit to the end because of this. It's ridiculous, and I'm angry, and every woman on earth should be angry, and I don't understand the women who supported Blake through all of this. We should all be furious at the damage that she's done to it, because Harvey Weinstein just had another mistrial because 9 women could not believe his victims. The 3 that believed his victims were all men. What world are we living in? We're living in a world where we've seen too many Blake Lively's. So all of those women who suffered and were asked, like I said, what were you wearing? Or why were you in a bar by yourself? As if that means these animals don't have to control themselves. They have a right to just violate you because you were in a bar, or you were wearing a miniskirt, or your lipstick was too red. We have been thrown back to those days by this nonsense. And how any woman stood by Blake through this nonsense, I will never understand. Shame on every last one of you, because you contributed to this. And now I've gone way off topic. But this is exactly what they're saying here. A foreign statute with noble aims that she's turned on its head. And that is what she has done, while refusing to acknowledge the serious consequences of her defamatory conduct. Because in addition to destroying the cause of women, she also destroyed all of these people and their reputations. And I'm not here saying that Jed Wallace is an angel. I mean, there's stuff coming out about him in this Rebel Wilson case. I haven't followed it closely. I just know whispers of it, so I'm not going to speak on it too awful much, because I will be speaking in ignorance, and I don't want to do that. So by doing all of this, I'm not saying that he hasn't done that in other cases. But what I'm saying is, we saw the work that he did in this case. We saw. It doesn't matter what he's done in other cases. Those are for other cases. They have nothing to do with what he was hired to do and what he ultimately did in this case. He did not deserve to have this defamation on him and his business from this case. If he gets it from other cases and he earned it, okay. I'm not here to tell you that he's an angel. But I'm here to say that as far as in this case, he did not do the things that he was accused of by Blake, from what we have seen in the Great Unsealing and the Great Unsealing Second Coming. She was not able to produce anything that proved this retaliation. And if she did have something, she would have had no reason to settle, and would not have settled, because she had to settle for $0, and that makes 0 sense. If she had any kind of secret thing that we had not seen, any kind of smoking gun, she would not have settled for $0, because here she is begging courts around the country for money. So obviously he did not do what he was accused of doing, or that there would still be this going on in court. Moving on to part 2 is about facts and procedural history. The CRD complaint named the Wallace parties as respondents and alleged that they engaged in conduct including sexual harassment, retaliation, failure to investigate, prevent, and/or remedy harassment, and aiding and abetting harassment and retaliations. The CRD and draft complaints were not available online or otherwise available to the public when filed, absent a written request for public information. So this is one of the issues that I spoke about before that was different when I talked about, because as you guys know, one of my Roman empires in this case was the New York Times, and the way that New York has grossly extended the protections to cover so many different things. And this CRD complaint is not public, it is private. So it was questionable to me how this was covered. But also, as he's saying, well, let me go on to what else he says about this not being available and stuff. Yet a reporter sent Wallace an urgent email the same day for comment, with the reporter stating that she had learned that Miss Lively filed a legal complaint against you, alleging sexual harassment, retaliation, among other claims. By early the next morning, the draft complaint was posted on the newspaper's website under the banner, "Read the Complaint." Okay, so let's take a look at what he's talking about here. So we have, to the right is the actual complaint that we see, but well, that's kind of confusing because it's all in the same exhibit, but there's two different. So there's this it's all part of the complaint. So there's these first two pages, and we see Judd Wallace and street relations. And then we see complainant is naming Judd Wallace, complainant is naming street relations. And then additional complaint detail says that respondents, and it lists them all, but it includes Judd Wallace and or street relations, engaged in a variety of conduct in violation of California Government Code section, blah, blah, blah. The conduct includes sexual harassment. And then we see the page that we've seen most often where it looks like a court filing. And so Blake has defended this by saying, well, this is the format of these complaints. You have the plaintiffs on one side, or plaintiffs and defendants on one side, and then you have the damages. And then on the inside, it talks about what these causes. Well, I don't know if they're causes of action in this, because this is not an official filing, court filing. I don't know what you call these, complaint for damages for. I'm not familiar with California civil rights complaints at all. But anyway, this is how they defended it. But if you look at these first two pages, on the left and middle, there is no distinguishing. It lists everybody together and says the conduct includes, as if all of these people are being accused of this conduct. So he has a very valid point. Also, this was not publicly available to people that they could go look. So if they just see this cover, what are they to conclude? That all of these people, including him and his company, are being accused of sexual harassment, when in fact he's saying, I never met the woman, I wasn't on the set. And this is defamatory. Any man, when he and his company show up like this, that he's being accused of this kind of thing, would take exception to this and would consider that they had been defamed by it. So we can understand the outrage and why he wanted to file his defamation lawsuit against her. He has a right to defend himself. Okay, 10 days later, Lively filed an actual lawsuit in the Southern District of New York. The document filed in federal court did not name Wallace or Street as defendants, which is kind of odd when you think about it. So this is the one, the first actual complaint she filed back on Christmas Eve, or New Year's Eve, sorry. It was Stephanie Jones who filed something on Christmas Eve. But as you see, he's not listed here at all. And then what she does is 3 weeks later, she files this petition in Texas. It's not an actual lawsuit, but she wants basically a fishing expedition. So she files this Rule 202 petition against him in Texas. And I talked about this way a long time ago when we first heard about it. Everybody else covered it as well, who was covering the case, that she admits in this that she wants to depose him to find out whether or not he was involved in this. It was pure and simple a fishing expedition. She said that she needed to investigate the scope of his conduct because she lacked critical evidence relevant to petitioner's potential claims, the specifics of the conduct by Mr. Wallace. She had the stuff from Jennifer Abel's phone, but she had to legitimize it. And so she really, really wanted this. Then she brought this action for defamation and defamation, or he brought this action for defamation and defamation per se, to hold Lively accountable for publicizing that plaintiffs had sexually harassed her, among other things, though they had never met. Lively knew she had never met plaintiffs, meaning she knew they could not possibly have sexually harassed her, despite what she said in her CRD and draft complaints. She also knew that she did not have a contract with plaintiffs, meaning she knew they could not breach some non-existent contract either. Plaintiffs alleged in great detail This the absence of knowledge and alleged that Lively committed her defamatory acts with malice. Lively later dismissed her Texas lawsuit and added Wallace and Street to her litigation in New York. Plaintiffs then amended this action to add factual bases for defamation based on Lively's action in Texas. Lively moved to dismiss, challenging venue, personal jurisdiction, and sufficiency of plaintiff's pleadings. The court explained it must first address jurisdictional matters, and if jurisdiction is lacking, the court will not reach the merits. So that's what they said earlier. They just had to see, and once they realized, oh, okay, we don't have jurisdiction, they did not proceed from there. They did not determine whether or not there were any merits to the claims. And so they ultimately said we don't have jurisdiction and dismissed without prejudice. And like I said, it is in the Court of Appeals now. Okay, now we get into the argument and authorities. And this is where they say it's not applicable in federal court. Just they came to the same conclusion that I had. I'm so proud of this. And based on the very same reason. And I wrote this I made this video months and months ago. This procedural versus substantive. This is exactly what I said. In diversity actions like this one, state substantive law applies, but state procedural law yields to the applicable federal rules. Considering a state anti-SLAPP statute that included mandatory fee shifting to a prevailing defendant, the Fifth Circuit determined that the statute does not apply to diversity cases in federal court. So this is binding authority in Texas. And based on the same conclusion that I came to, that procedural law yields, state procedural law yields to the applicable federal rules. And it's based on this anti-SLAPP thing. And here is the very, very important thing. Lively herself compares California Civil Code 47.1 to California's anti-SLAPP laws. And she made a fatal mistake doing that, because now she has admitted that it can be compared to an anti-SLAPP, and anti-SLAPP has already been ruled to be it doesn't work in the Fifth Circuit. So she did it, taking her at her word. Another beautiful phrase here. Section 47.1a is similar to procedural state law that is inapplicable here. And I've went to where she said it. This is document. Sorry, my time clock at the top covers. So, but I always put the document. I always try to put the document numbers there. So, if you want to look up what I'm referring to, this is her document where she says the California Supreme Court has held in the anti-SLAPP context that a defendant who prevails on jurisdictional or other non-merit grounds is nonetheless a prevailing party entitled to fees, and uses this this California case law. But right there in her own filing is them comparing 47.1 to anti-SLAPP, and it doesn't look good for them because of this. Fifth Circuit says, no, you can't apply these here. They're no good here. It's one of the circuits that does not allow anti-SLAPP in federal court. And so she kind of cooked, if it does get accepted into, if his appeal gets accepted, it's not going to work here in there. So this is the video that I made. I forgot what month it was. This is the one I'll try to remember to link in comments, so that if you didn't follow me back then, or if you haven't seen this, oh, did you, Lisa? You recently watched the video? This is the one. This is the one. So if you haven't watched it, I explain it in much better detail, and that I don't have time to do in this one because this one's already so long. I'm getting close to 2 hours already. But this is the video of how I went about coming to my personal conclusion of what my opinion was, how this would all end. That I love because this is what the Fifth Circuit said, and we'll get to an even bigger one in a moment. But this is a slide from there. And this was talking about just the anti-SLAPP, which now we know Blake has admitted 47.1 is very similar to, but these are the reasons. So, as I said earlier, that if there's a conflict between the federal rules and the state, when it comes to procedure, that federal always takes priority. And anti-SLAPP comes along and does conflict with the procedures, specifically dispositive motions like 12b6, things that the federal government has already said, you have a right to file this, and these are the rules. Now this anti-SLAPP comes along and says, oh, okay, forget all that. We're going to do it this way. But they cannot beat what's already established in the federal rules. They're a state law. They are not federal. Things like the standard for dismissal. So the timing, the fees. Is there fee shifting? Yes, there's fee shifting. Is there burden shifting? Yes, there's burden shifting. Well, those are all procedure. And that may sound confusing now, but once you watch the video, you'll understand what that all means. But I can't tell you how delighted I am to see this happen. Okay, then we have, where am I? Don't want to lose track of myself here because I added some videos, or some slides to the video that I didn't have in my original printout. So my pages are a little different. Okay, 30. This is now 32. All right. Now here's the other reason I mentioned earlier about without malice and factual information. It's not possible to prove these things without evidence or adjudication. But she wants this stuff enforced without considering any discovery or collecting any discovery. So this is what she's asking the Texas court to determine, to say, well, this is protected under this statute that isn't applicable in your circuit. But the rule itself says without malice and factual information. That requires, I've already talked about that, so I'm not going to get back into that too much. But so if you compare anti-SLAPP to this 47.1 California state law, no matter what they try to say, this is the whole looks like a duck, walks like a duck, quacks like a duck. You can say, oh, well, we're not procedural, we're substantive. But really? Because anti-SLAPP protects speech from retaliatory litigation, and 47.1 protects harassment-related speech from retaliatory litigation. Anti-SLAPP has early dismissal mechanisms. 47.1 has early privilege-based protections. Anti-SLAPP has fee-shifting provisions. 47.1, fee-shifting provisions. Speech immunity concepts designed to deter chilling lawsuits. It looks like a duck. So in these circuits outside of California that will not entertain anti-SLAPP, they are going to look at this conduct, how this performs, and they're going to say, it's anti-SLAPP. We don't do that here. As is what Jed Wallace is saying. And it's completely what I said in that cut off the nose video. Now we get to the very, very exciting, shiny, brand new Supreme Court case, Burke versus Choi, decided in January, so just a few months ago. Sorry, keeping up with my slides here. And it is the principle behind this argument that I made. It is a medical malpractice case. It's not a discrimination case or a harassment case or anything like that. But we're going to get into why it affects much more than that. It addressed a state statute. And this state statute, it was from the state of Delaware, that they were trying to enforce. So similar to Blake trying to enforce this California statute, but this Delaware statute conflicted with the federal procedure. And so it went through the court, and then it ultimately made its way to the Supreme Court. And the Supreme Court said, look, we decided this stuff a long time ago. When procedural statutes conflict with pleading requirements of Rule 8, state procedural law must yield to the federal rules. Bam, done. So Lively's request to determine her privilege defense under a California state code conflicts with the plain meaning of Rule 12b, which limits courts to making jurisdictional findings of fact in deciding motions to dismiss for federal or for lack of personal jurisdiction. California procedural law must yield to the federal procedure. Bam. Done. Pure and simple. So says the U.S. Supreme Court. And I really, really hope that, and I actually sent, this is the first time I've sent an email like this to the Wayfarer attorneys, because they still have to deal with 47.1. And they're dealing with the New York Times case still. So I sent what we're going to talk about now, because this makes it an even bigger deal. I sent them the link to this case because I'm sure they're watching this Babcock. So this is the Oklahoma Bar Association. They printed this in their Oklahoma Bar Journal, talking about this Burke versus Choi and the effect that it's going to have around the country. They say the whimper almost no one heard coming. Burke versus Choi and anti-SLAPP statutes. So the Oklahoma Bar Association, they took this decision and they're like, oh, this is going to directly affect anti-SLAPP. And they wrote this whole long article about it. I just kind of want to skim through it really quick and not spend a whole lot of time. But they say Justice Amy Coney Barrett's opinion in a study in unassuming simplicity. It is the kind of judicial writing that seems almost obvious in retrospect until one realizes how much it likely quietly forecloses. And then it talks about this case that I just mentioned. And it says the Supreme Court said no, that it was inapplicable in federal court. The court explained why in a manner that likely has implications extending well beyond certificates of merit, that any state I've got something covering my, there we go. That should give pause to anyone who has assumed that state anti-SLAPP statutes occupy some special exemption from the ordinary rules governing federal procedure. That it keeps coming back, saying the Supreme Court's response was a firm no. Even if one accepted creative license with state law, the federal rules of civil procedure already occupy the field. They already have 12b All the 12B settles all of that. And it's there. You bring something from a state law, you can't compete with what federal rules have already established in procedure. So let me look at real quick again at what's important here. A state law that purports to impose a different standard, whether styled as a pleading requirement, an evidentiary threshold, or a gatekeeping mechanism, necessarily conflicts with this comprehensive federal procedural scheme. Once federal law occupies a field, that's it. The state cannot come up with something that's stronger than it and that fights it. Because it introduces dissonance into this uniform system. So basically, anything that comes along and tampers with the system that they have well established long ago with Erie Doctrine and all the cases that came after it to clarify even further, you want to come in and bring this stuff in and mess up what we've already established, it creates chaos, it creates dissonance, and it is a hard no. So 47.1 is going to have a difficult time now that this case has been determined in the Supreme Court. And I kept saying, I hope this 47.1 goes to the Supreme Court so that it can be rewritten, so that there can be this protection for women, but not be so, not cut off any kind of rights of the accused because of cases like Blake's. So then they go into great detail. So I'm gonna, like I said, skim through because I'm getting close to the 2-hour mark. But look that up. Like I said, it's from the Oklahoma Bar Association. I'll link that too along with the video. And this is the article. So I would definitely recommend looking it up yourself to read it more thoroughly than what I'm doing here. But it will wipe out any issue that looks like this, where state law conflicts, because some of these are being forced, just like that one was a medical malpractice, completely unrelated, but it's the principle that will stand, and as they have concluded here, will have a huge effect on anti-SLAPP. So here's one of the big things. One of the things is early dismissal based on this evidentiary showing before any discovery has occurred. That's what Blake has been trying for, saying, I don't have to prove anything. I don't have to provide discovery. I'm protected. My statements are protected. This is like, no, that's not what 12B allows. It talks about how anti-SLAPP gives movement an immediate right to appeal a denial of a dismissal motion contrary to established practice in federal court for most allegations or evidence-based dismissal motions. So all these little workarounds that these anti-SLAPP type cases have brought in, they go against federal procedure, and now they will not be permitted to stand because of this binding, absolute binding authority. This whole fast track dismissal going to be gone. Initial burden is on the party seeking dismissal, because there was burden shifting, remember? So it's like, instead of me having to prove this, you have to prove it. But no, you don't get any discovery to prove it. So how are you supposed to prove it? Just like 47.1, how are you supposed to be able to prove malice if you don't get any discovery? They can prove malice now based on all of this discovery that they've had. So it's, to me, it's a beautiful, beautiful thing, because justice needs to be fair. And this 47.1 simply was not fair. And the New York Times, that was not fair. They're filing an anti-SLAPP saying that these people, even though they based their article on stuff that was not a lawsuit, not only that, they admitted that it was based on thousands of pages of texts and emails. Thousands of pages of texts and emails were not in this complaint or lawsuit. So they looked at stuff that was outside of any judicial proceeding or any court filing. That is not protected. That's one of the things that Judge Lyman brought in unpublished cases to try to justify on behalf of the New York Times. But it's simply not what's in the law code. They stepped out from under the umbrella with this. And now they want to file an anti-SLAPP when we've clearly seen that if they saw thousands of pages of text messages and emails, none of those proved what they wrote. We've seen it. The evidence is not in those messages. What they said was just completely based on Blake's allegations. It was not based on these thousands of, if they had really read these thousands of pages, they would have seen it wasn't true. So it's sick that they're using the umbrella of their freedom of press, and then also going to come back on top of that and file this anti-SLAPP that they have now filed in New York State court, because it's not something they could have filed in the federal court, but they've got it going now. And I sent this to the attorneys. I sent it to Kevin Fritz and Brian Friedman and to Ellen, and hoping that it would help them in the New York Times case. But whether one styles the requirement as a special motion to dismiss, like 47.1, or a precondition to proceeding, just as the defendant in Burke, the substance is the same. It straightforwardly conflicted with a rule, a federal rule. So, yeah, please go and read this. It's extremely interesting. But I love the conclusion. They say the substantive purpose of the state law, the court said, makes no difference. It doesn't matter what it was for. What matters, said the Supreme Court, is whether a valid and on-point federal rule of civil procedure governs the manner and means of enforcing rights. That's all that matters. Burke now likely forecloses this argument. It's a beautiful thing. Hey, Michelle Chaton. New York Times has freedom of press, but tag Wayfair and Street don't even have the freedom to text people. Yeah, in the workplace about what is happening in the press without being sued for doing so. It's so backwards, and it's so New York. It's so bad. All right. All right. So coming right in, just under 2 hours. I made it through, and I'm so excited to go watch the Kevin Fritz interview. More excited than I can tell you. And like I said, I hope that you guys will follow as I go back into the Wayfarer stuff as well, because all of this stuff is winding down right now. And I will be doing some from the beginning episodes to catch you up. Any of you who did not follow this from before, his conviction was reversed. I'll talk about the reasons why. Omar's going to cover it also this weekend. And then I will go into the whole story of how the whole story took place. And like I said, this other case that is threatening content creators, once again, my name ended up in that case. They were not able to find me, to depose me. It's one of the big reasons I was outside the country for months for a while there, because I was really, really worried about that case, more so than I was about my subpoena to this case, because well you'll learn all of that. It's a very frightening situation. It's a billionaire who has done stuff like hire ex-FBI. He's hired PIs that will set up cameras across the street from people's private homes so that they can monitor when they leave the home and follow them. This man had a whole documentary created. He had journalists set up. He had real bot farms. He had real trolls. He had all kinds of stuff. All of the things that Blake claimed happened to her was actually happening in that case. So, You'll hide me? What is that? Thank you. So there are so many juicy bits. And like I said, I went to that hearing because it affects content creators. It affects a woman. This woman is being targeted, harassed, defamed, all in an attempt to humiliate and stop her because she is one of the ones out there telling the truth. And it's why my name came up. Because I was reporting on the case. There weren't many people talking about that case. As far as I know, there was just Mandy and Liz and myself. And because we were covering it, we got targeted. And along with people who help, who are friends with Mandy, or maybe did a little research for her at some point. But there's juicy stuff. There's the same thing. There is the taking of someone's private text messages through iCloud. There's a felon involved who's doing the harassing. He's the same felon that I came across. He almost shut my YouTube down. I had 2 strikes. One more, that's it. You're done. And you can never make a new YouTube channel if that happens to you. And he had me almost there. And yeah, he's the one that's doing all this. There's just a lot going on with this case that is extremely interesting. A lot of the same stuff that happened in this case, but a million times scarier. Instead of XCI, they have XFBI. I think I might have already said that, but and the attorneys in this case are absolutely lovable. I've met I met so many of them yesterday. Was like I said, it was super cool because they knew who I was. They watch, they send links of my videos to other people. So it was super, super cool to talk to them in person. And I'll share a photo of one of them. I know you guys will love these people too. They're absolutely wonderful, wonderful people. One of them that I haven't gotten to personally meet yet, he wasn't there, but he had a huge part in the original murder conviction. So yes, Diane, that's the whole point. Yes, there needs to be new laws made for content creators. Yes, we need to support these cases. We need to write these courts and get favorable decisions made for us to stop this harassment, because I stopped covering the case when my name showed up because I am truly scared of this man. If he's out there working with felons, allegedly, stay away from me, Deborah Barbier. You are an embarrassment to women that you're doing what you're doing. Stay away from me. Do not try to subpoena me. Stop asking people about me. I didn't have my channel when this stuff happened. I've never revealed anything that was not publicly filed or already publicly out there. That's the woman asking people about me, asking people if they know me, asking people where I'm located. And she's the one that, if you saw the video I did with Omar, she's the one who asked this woman who's being stalked, like it's the 1960s, asked her, "Did you post a picture of yourself in a bathing suit?" You know what? I'm going to show you guys that. Let me load that video because it is awful. This is what we're up against, and it is a woman. Is it too? Oh no, it's too big. Oh wait, here it comes.
Okay. Now, you also posted a picture of yourself. Yeah, just a few days ago, you posted a picture of yourself in your bathing suit, right?
Oh, yeah.
Okay. And were you on the beach? Were you on the beach in your bathing suit?
Your Honor, objection. This is not relevant and harassing.
Your Honor, if she has security concerns, the last thing a female with security concerns does is post a bathing suit shot of themselves for their stalker to see. So I'm curious as to whether she acknowledged that she did that.
This is beyond the pale, Your Honor. Women are allowed to.
The last thing, do you see what she's doing? She is victim blaming. It is vile. It is absolutely vile. This guy stalking her, she has never alleged that it was a sexual type of stalking. It's not. He is some loser on TikTok who thinks that Alex Murdaugh is innocent, and he is so jealous of Mandy's success because a Hulu series was made about her podcast. Yes, victim blaming and slut shaming. And she was not on the beach. And even if she were on the beach, she could be on the beach in a string bikini, and it's not this woman's business, and it has nothing to do with what's happening. But she was in her private backyard, in her private swimming pool with her husband. And she posted a video of herself faced, like body down on a raft. You couldn't see her breasts. You couldn't see anything. She was laying on her stomach. You saw her face, her arms, and the back of, like, I think from the calf down. But she never said she was being stalked in a sexual way. And it's, even if she was, she can post this. It's disgusting. And this woman saying what she said is so vile, and the judge's reaction is just as vile, in my opinion. You'll see.
Be in public in a bathing suit.
That's not the point.
It's not the point. Go ahead.
That's not the point. Then what's the point, Deb? What's your point? And him right away jumping, like, whatever Deb says. It was disgusting to see at the hearing yesterday. Whatever Deb says, he goes along with. So he jumps right to, that's not the point. Then what is the point, Your Honor? What is the point? Can you explain what the point is of bringing it up then, if that's not the point? Oh, this is just maddening.
Did
That
you?
was in my backyard, if you really want to know.
Okay, but you
Which
posted a
husband?
bathing suit shot.
My husband right next to me, and it wasn't a revealing bathing suit shot. Ethan.
But you posted a picture of yourself in your bathing suit, correct?
How many times is she going to say this? Like she did something, like she committed a crime. This is why I want so much attention brought to this. I'm going to post the courthouse, so that if any of you feel, and I'm not inciting anybody to do anything, but if any of you feel that you need to say something about what you're seeing here and about this judge's reaction to it, that I will help you find the address.
Okay. And you indicated on examination from your attorney that you've been getting, people have been saying mean things about you for about 6 years now. Is that right?
It's not just mean things. It's been people saying stuff about her hanging from a noose. Stuff about, I don't want to say words that's going to get me, get this thing reported, but other kinds of things like that. Use your imagination. Not mean things.
But you haven't provided the
Death
score
threats.
or in any of your filings with one document that shows that anybody has threatened to kill you, right?
Did you want that in part of the each case?
No, I'm asking you, have you received a specific death threat?
I could provide that.
Your
I
Honor,
want to look into the time
She showed some of those death threats yesterday.
worst time of my life, and all the most horrible emails I've ever gotten.
can I have a
For
girl?
users to know if I feel unsafe. I
Great,
feel
this
like
sounds
that's,
really
again,
awful.
it feels like harassment. It feels very intentional. Like you want me to be miserable, and you want me to go back to that time in my life where I feel so unsafe.
And
And if you want that, behind it.
I would like to be heard on this, Your Honor. We have been very intentional to protect Miss Matney's security. And posting specific threats that she's gotten, posting very specific security
One more thing on here. I
steps
want
that she's
to hear.
taken to keep herself
I
safe
can't remember where it's at.
harms her security. If they really want to see those documents, we can find them. I don't see how they're at all relevant to this case. But that's, if the court wants to be upset about those not being posted, that's on me, because I would advise my client, and I would advise any client not to post specific threats that they've gotten like that.
Yeah, I agree with that. Let's just move on.
Okay, I'll move on. Ms. Matney, you indicated in your examination with with your attorney that Ms. Farrell was asked irrelevant questions during her deposition, according to you, right? And you indicated that she was asked about her finances. Is that right? And
Okay, that wasn't there. Sorry. It was the point that it was making it like, you know, what kind of threat does she have to please you for it to be enough? But yesterday she brought the things, the death threats, and read them in the court, and it was absolutely disgusting. They brought item after item, and the judge would not accept it, and there was no jury. It was to determine her mindset for something. You know what? I'm getting too far into that. I'm going to cover that this weekend, probably tomorrow. But the hair tossing is making my eye twitch, and it's constant. It's constant. It was the whole day yesterday. It's constant. But she also represented the attorney that helped Alex Murdaugh steal millions of dollars from very vulnerable clients. So I do not have much love in my heart for this woman. Let me just say that. But just to give you guys a taste of what is going on right now and how this podcaster journalist is being treated in the court system. What the accusation that they made is that she shared a video that she never saw. That's been clearly established that she's never had it. There's no reason that they're still pursuing her, but they are still pursuing her because they don't like the things that she says. They don't like her reporting. And so this is what's happening to her. They are endlessly harassing her, defaming her, humiliating her. And it's all because she speaks out about this case. And it's a dangerous trend. It is such a dangerous trend. And we need to do what we can to stop it, because it's not right. And I mean, you guys all love to come here to YouTube and hear us content creators be able to express what mainstream media is not reporting on. This case, for example, very little gets reported on this in mainstream media. And you saw what happened with the Blake Lively Wayfarer case. Very little got reported on that, and it was very skewed. So if they can effectively silence us by threatening us and scaring us like this, then we're gonna all lose this avenue of reporting. And I don't want to see that happen. And we can't let this happen. So that's why that case is so important, and it's also really interesting. I'll make sure to catch you guys up on it, because this case here has been happening for like 4 years. So there will be a lot of catching up to do, but I'll make some videos to help catch you up on it. So anyway, yeah, this do you admit that you did this? That's crazy. I hate it. I hate it. I hate it. Hate it. All right, guys. Thank you so much for joining me. I'm going to try to be back tomorrow with my report on this case. I got to go through all my notes and make my slides on it. And anyway, I hope to see you guys tomorrow when I talk about it, just because of that fact. I mean, if content creators are important to you, and if us being able to freely speak without being made to fear being hunted down and humiliated like this, then please come and support that. Anyway, have a great night. I will see you very, very soon. Thanks, Christina. And Jane too. Jane was here earlier.